So as in eviction, what is to know about eviction from the aspect of tenant? So if you are looking at more of eviction, you can go back to the chapter on landlord. But this one, I just want to touch on eviction on the aspect of tenant. About a specific relief act, that you cannot just evict a tenant forcing him out by violence. That means the owner of the house or the landlord in where cannot just force the tenant out. You have to understand the position of the tenant. Knowing the tenants you have tried most of the thing to ask the tenant to pay. Tenant has tried all the means to pay, but still unable to pay. So in such a very difficult decision-making process, the tenant is given chance a few times to pay up. So this is the right of the tenant, not because of one time not able to pay, the tenant is evicted immediately. A lot of time in residential situations, there are at least 2 warning letters. The first one to tell the tenant to pay, the second one to remind the first letter and telling the tenant again that this second reminder. The third, only then it is time to proceed to the eviction, as I mentioned just now. But then always talk to your landlord, just in case that he is able to wait for a while and then let you reorganize yourself. Probably just try to have a settlement in between so that there is no violence. Because in a lot of cases, locking up and jumping down from the balcony dangerous, become a violent aspect. And as a tenant, if you are being locked up unnecessarily, you can actually lodge your police report against the person who locked you up, because that is dangerous to your survival, dangerous to you as a human being in the house. So tenant has a right to live as a human being. Should not go and commit suicide or kill yourself because you cannot pay rental. So life should not end like that. So life should give yourself a chance. Go back to your whatever friends, maybe stay with a friend or stay with a relative, or go back to your hometown. Rest for a while before you make another attempt. So this is a part that I feel landlord, whatever is a more powerful scenario, the law has given a lot of allowances for the tenant because the law protects the tenant. So use this advantage to your fullest, but then at the end, don't take it for granted. Don't take it for granted as a tenant that this eviction law means the landlord has to go to court. This is a process the landlord usually will take time. The landlord usually would not want to go to court as well, and both parties will not want to go to court as well for settlement. So both parties should talk nicely, try to solve a problem, and indeed cannot solve the problem, the tenant should move out and look for places to stay temporarily, or go back to hometown, or go back to where you came from, go back to the state where you have a peace, and then recollect yourself, not to cause trouble to a house, not to damage the house, not to have angry response and fight with the neighbor or fight with the landlord. No point, because at the end you are here to stay in this life, to enjoy living in this world, not to be sad and despair in this war of stress and pressure. So you still can actually go back to your origin. So this is my own experience, having to go through some of the tenants who are in trouble, in situation of trouble. In fact, you go back to my earlier chapter on landlord, you hear some stories how I had some tenants who are very unfortunate. So that I can understand. So the danger of misrepresentation in the case of tenancy is that sometimes as a potential prospect, you go and view a place, and later you found out that when you so-called chose to rent this place, everything appeared different. Initially it was so nice, but then when you actually walk in to take the keys and go into the house, everything has changed. This can happen, and it is a tactic sometimes by the agent or by the landlord. So putting nice things for you to see, and then when you actually take the key and go in, a lot of things are no more there. So I put it here, example, what you see is not what you get. TV there was a nice TV, but then after you move in, take your key, the TV is no more there. So you have to do a few things. First, as a tenant, prospect tenant, you have viewed the place, and then you take pictures. You ask for permission to take pictures. After having done so, then you are satisfied. Then you can say that yes, you are putting up a booking. You are putting out a booking for this place. Don't pay the whole lot. You're putting out a booking and telling the agent or the landlord that you want to be on condition that the thing is as you see, what you see as in pictures or whatever video you have taken, that eventually when you sign the tenancy agreement, you want to see the same picture having the same item in the house. You will not pay the security deposit until you see everything is okay. So that part is the first step. After that, you wait for the agent or the landlord to provide you the tenancy agreement draft. Do not sign anything yet. So you actually read through the whole tenancy draft and look at the terms which may be obligation that you cannot commit. Let's say you cannot commit certain obligation, then you have to discuss with the agent or the landlord. And if you see that there is something that is unfair to you, then you highlight it. So if you want to negotiate for this diplomatic clause or expatriate clause to be inserted inside, you also discuss it at this point of time. Deal through an agency is good because if you pay the booking fee will be as a booking fee by the agency firm. So the agency firm will put it inside the client's account and not transfer to the landlord. So the booking fee is with a condition that eventually the tenancy agreement and the things are in accordance to what you see. Sign and pay up only when you are taking the key. That means when you are going to take the key from the agent or from the landlord, you go into the unit, the house, and then go through the whole list again. If there is an inventory list, go through the inventory list, exactly items, what are the items that you are taking over. And if you find that your previous visit, there are things missing or not in the inventory list, it is your right to tell the agent or the landlord that you want a similar replacement or you want a certain thing and negotiate it out before you sign on the dotted line, before you sign on the tenancy agreement and pay up your security deposit and utility deposit. So this is the steps that you should do. Do not go and pay the whole lot while having not exactly see the house, or you have not actually seen the contract. So do not ever, I repeat, do not ever pay up everything before you take the key or before you have a exact physical look at the place with the tenancy agreement. So you only pay up everything when you read the tenancy agreement to your satisfaction and has gone into the house and check all the inventory, what are the things that you are supposed to take over. Best is you have pictures. So now the tenancy agreement usually come with a CD recording of the video inside the unit. Right, what are the dangers during inspection? So with condition means that you have pay up your booking fee, and with condition that you inspect the vacant possession, inspect the appliances, existing defect, damages, and only then the final part, signing the tenancy agreement. So what you see is what you get. You cannot be signing on things that you have not seen. Sometimes the TV may not function. You go into a house, you saw a nice TV, but then the TV is not in good order, already need repair, and you didn't know that it is actually not good state. So you sign up, and then later you went traveling. After 1 month, you back from traveling, then you found out TV not working. Then the issue is the owner will say, no, the TV was in good condition. You took over and the TV now need repair. It's your fault. Then you get into trouble because you did not check. So by right, by the time of vacant possession, you take over the key, you check every equipment. check everything, and then if everything okay, then only then you sign up the tenancy agreement and pay up the whatever security deposit sum. Advantage of using agent. Now, this part I must say that it is agent's guidance. If you have a good agent, then the agent would look after your interest. So in this case, document, he would help you up with your draft agreement. Agent is not doing the agreement for you. Your way of terms and things like that is between you and as a tenant and the landlord. Agent is not to do a tenancy agreement for you, and he's not a lawyer. He cannot be doing a tenancy agreement for you. So the agent can help you up, checking the tenancy agreement to see all things are in good order, and warn you on certain things if he finds, as an experienced agent, he finds the situation warrant your concern. In fact, a good agent would also advise you on certain things, and his role is actually to ensure both sides actually are protected. His role, of course, he is appointed by the landlord, so he actually protects the landlord from getting cheated. But then in a way, if you are a nice person, he has no reason not to help you out as well. So if required by the landlord, he would make sure things are explained to you, and then so that you can understand what are the things that is required by the landlord. Now the booking, if you place it with the agent, agent will put it in the agency's client's account. Don't pay him cash. You just pay him cash, he can just disappear. The agent just disappear, taking your money. So pay to his client's account in the agency, and therefore the agent would have to do his work to make sure that things are okay. And if things are okay, then the whole lot of money you pay with the security deposit, everything to the client's account. So the money all in the client's account. The sales and purchase similar, tenancy agreement also similar. Whatever the agency is doing is in the client's account for the client's money. So when the client's money booking fee is in the client's account and you disagree, let's say after 2 weeks, then you found out that when you are supposed to take the key, a lot of things was misrepresented. A lot of things got missing. Then tenant can actually say that no, this is not the unit I wanted, because you have done in a way misrepresented. So you can exit by not signing the tenancy agreement. You can exit by saying that no, this is not what I had negotiated. Then the tenant right is to be ensured by the agent. So that is the reason why I said, when you first do the viewing, if you are interested in the house, please take pictures. And when you have that documented in your evidence, and in the way that when you eventually need to sign the tenancy agreement and you found out that things have changed, the evidence is there to prove that when you first came and view and put booking, it was not the same now. So that means the agent would have no choice but to return you the booking deposit, because there was no meeting of the mind, there was no contract, because the initial expecting a house had been documented in the picture, and now the house has changed, it is misrepresented, and you can walk away, because misrepresentation is one of the elements that can cause a voidable contract. You recover your booking fee. Owner selling it, this is important, I want to emphasize. Sometimes this situation where dispute happen, when owner wanting to sell the property in tenancy, what will happen? So residential property is a headache, because owner wanting to sell, but he has a tenant in there. So new owner doesn't want to continue renting. So the new owner say, I want to take over the house, I don't like your tenant, I want to use the house myself. Then it becomes a dispute. So what is the solution? A lot of these things happen, and eventually I think the weaker party is actually the tenant. No choice, because the new owner doesn't want to rent. So end up new owner force the owner to vacate. However, between the happening of the incidences, dispute happen, what is the correct legal solution? My interpretation is like this. If the tenancy agreement has the clause that the owner need to continue renting and the new buyer has to accept this tenant, that means in the writing, when the clause is stated that tenancy ongoing and new buyer has to accept the tenancy, then the previous owner, that means the old owner, has to look for a place for the tenant. So in such a situation, the old owner, the previous owner, in case of selling to a new buyer who doesn't want to inherit the tenant, the old owner has to look for a place similar to current place for the tenant to move out. In such a situation, if the tenant doesn't want to move out, then it is tenant's fault, because the tenant's relationship with the landlord is that in the contract, it has mentioned that the owner has a option to offer another similar place to the current tenant. So if it is stated in the contract that the owner need to look for a new place, or interpreted or implied to look for a new place, then the tenant has to move out to the new place, continue renting with the current owner, the new owner take over the house. However, a lot of time the old owner doesn't want to care, and this is the problem. The old owner may feel that the tenant also not a good tenant. So this is a way to get the tenant out of the house, and he wash his hand, he doesn't want to care. Bring it away to another new owner and expecting that this is a method to get rid of the tenant. This is law not right, because in the contract it already says that by tenancy, the tenancy, as long as the current tenant pay on time, he has the right to stay until you look for another place equivalent for him to continue staying. So this is a problem. But going to the new owner, bringing the dispute to the new owner will always say, I got nothing to do with this. I bought this property without knowledge of this particular clause in the tenancy, and it is not my so-called, it's not my obligation because I am not the owner at that time. Because he doesn't have a meeting of mind in the tenancy agreement. He was not even in existence at that time of negotiating for the tenancy agreement. So he is not the person responsible for the tenant. So the tenant no need to go and plead, ask for forgiveness or whatever with the new owner. New owner has nothing to do with the current tenant. So it's only the old owner, the previous owner. So the owner selling by recovery of specific immovable property, this is the eviction, Special Relief Act, where specific immovable property has been let under a tenancy and that the tenancy is determined or has come to an end, but the occupier continues to remain in the occupation of the property or part thereof, the person entitled to the possession of the property shall not enforce his right to recover it against the occupier otherwise by proceeding of the court. So even the current tenant who is staying now is supposed to be squatting already, he's squatting in the new owner's place. So in such a situation, the new owner wanting to get rid of this old tenant, he has to still follow the law. He cannot just go and kick this tenant out. He has to follow the law to file, but then when he files, he will have problem because he doesn't have the tenancy agreement, because the tenancy agreement is between the old owner and the tenant. It's not between him and the tenant. So this type of situation, the best solution for buying a property that is tenanted is to have a good settlement. At first, looking at the tenancy agreement, come to a good term with the current tenant, take over the tenancy. If you do not need to worry so much about the tenant, the tenant is a well-behaving citizen of the country, take over the tenant. And if the tenant really mess it up, then you can apply to evict the tenant. But then if you say you ask the old tenant to get him out before you take over, that is another way to do it. This means that the old owner, the previous owner, may not be helping up too much, and the only way out you can do it is don't pay him. So when you buy a property from a tenanted house, you don't pay up until he actually vacate the house for you. So if he doesn't vacate the house, you ask your lawyer to retain the payment, especially the bigger sum, which is the loan release. You tell your lawyer not to release the loan until he evict or he make the tenant to go away. So you take over a house when the house is totally empty lah. So this is the situation. A lot of time, some buyers they thought that the tenant is nice, so they actually fall into trap lah. So when they inherit this house tenancy, then they found out that this is a recalcitrant tenant, very hard to get rid of. So then therefore I have to go through the eviction order and all these things, which is a problem lah. So anyway, owner selling, the new owner not renting out. So this is a headache in commercial also, because the owner has sold the tenancy with tenancy, and then the new owner doesn't want to continue renting. So what happened? Especially the tenant who is doing quite a good business, you have problem because you cannot move to another place because you are making a good living at this commercial property. So the new owner wants to take over. The new owner sees this opportunity for him to take over, so he bought this property and thinking of taking over and using it as his own commercial outlet. So therefore, you have to execute your right as a tenant to buy the owner. So that means you usually go to court in this commercial situation or dispute. The right of the tenant, tenancy agreement, new owner doesn't want to rent, tenancy still with the old owner, no contract with the new owner. At the end, you are not a party to contract with the new owner. So how to take action against the new owner? You only can take action against the old owner based on the tenancy agreement. So you claim against the old owner. So the old owner sometimes say, okay, I meet you in court and see how we settle it in court. So some of this situation, if you happen in a condition of very important or big sum of money involved, you caveat. So you lodge a caveat if you have a long-term lease registered. So that means the previous owner cannot deal. He cannot deal with the property because you have a caveatable right. The reason in situation is this interpretation of the caveatable right is up to the registrar of the land office. So the registrar of the land office must see it as a covetable right. So to give an example of what is a covetable right, if two persons come to a business and form a partnership or a Sendian Berhad and start doing business with a plot of land. Now, one party pull out and want to sell this land. The other party can stop the selling of this land because he has right in it, so he has a covetable right. Then another example that the covetable right is misused or abused is when, let's say we have a lot of time situation of having another wife or mistress, we call it mistress. So the mistress is staying in the house. Now over time there was a dispute over time, and the owner, of course the boyfriend said that he wants to sell the house. So the mistress goes to the land office and try to stop by lodging a caveat. So in law, this type of caveat is no caveatable right, because he is a mistress, not in law wife. So if he is a wife, really legal married wife, then she would have a caveatable right to the house because of the marriage law that's protect the distribution of property among husband and wife. But the mistress is not a wife, so the mistress has no cavetable right to the property. So similarly, if the situation that commercial property where you are a tenant, you have a relationship with the landlord, and the landlord sold it to some new buyer, then you have a cavetable right because you are a tenant of the property and you rely on the property for continuing your business. So you have a livelihood that is tagged to this relationship of tenancy. So this is a cavetable right in law. You even have a right to even register this tenancy lease in the land title. If it is a long-term land title, long-term lease of 20 years or 30 years, you have a cavetable right, not allowing the owner to transact the property. Sublet and subtenant, now this one I talk in length in land owner, the landlord chapter, so you can revisit that chapter. But usually in commercial setting where you need to do a subtenancy agreement. Now this subtenancy agreement must not exceed the scope of the main tenancy. So it's like in a case of a handphone shops, a lot of mini handphone store in a commercial floor, let's say a complex. Then, well, there could be a main tenant who signed with the owner, who is the owner of the complex. Then this main tenant actually sub out the floor space to the individual phone shop. So this individual handphone shop is a subtenant of the main tenant, and the main tenant in fact had a tenancy agreement with the owner of the complex. So this is the usual manner how it is arranged. So the subtenancy can never exceed the main tenancy. So the main tenancy has probably a duration of the 2 years. Then the subtenancy cannot exceed that period of time. Okay, in my conclusion for this chapter, tenant, I have gone through tenant as a major group of people who come to renting a place, mainly before they eventually own a property. So tenants are stressed as a weaker party because they are hoping to just pay off their rental and then able to stay in peace and do their work. So there are laws that protects the tenant for this purpose, for hoping that usual abuse over tenant protected by the law. So the usual abuse, like discrimination, I do not want to rent it to certain types of people. I do not want to rent it to blacks or whatever. And then this is the problem of the Malaysian situation sometimes. So the Residential Tenancy Act is also drafted on this purpose to try and avoid or to disallow all this discrimination. But there's a lot of argument on this. I mean, as an owner, you have all your right to choose what type of tenant you want. So this is also very hard to implement. So legal tenancy agreement is important, in effect making it in written format so that both parties understand their obligations and the duration of tenancy. So this is important because it puts everything in order, and in case there is a eviction required, then this tenancy agreement need to be presented to the court, and a fully stamped, adjudicated tenancy agreement is basis of how the court would to award the eviction. For feature and the performance of the tenancy, where I have spoken about performance means you have to complete the whole period of tenancy duration which is agreed in the tenancy, maybe 2 years, maybe 1 year. If you do not fulfill, then there is the right of the landlord to forfeit your security deposit. And even in some scenarios, especially in commercial scenarios, there can be performance reason that the landlord can claim the eventual performance. So you have to get a new tenant for the landlord, or you have to pay up the remaining amount, which is the next half a year or even 2.5 years. The example I gave was half a year and 2.5 years just now. So COVID Bill 2020 became COVID Act 2020 on the 23rd of October. So lastly, before I finish off the issue of process, when you take over a property, the process that you have to ensure as a tenant to not pay up until you are satisfied with all the inspection that it satisfy you, and only then you pay up your amounts, deposits and everything to the agency company. If you are dealing with the agent, only pay to the agency client's account. Even your deposit and whatever booking fee is paid to the client's account of the agency firm, and let the agent settle the things with the landlord. The agent will have to claim their fees and then remit the sums to the landlord, and the landlord produce the monthly receipt for your rental. The agency firm would show you whatever you may have paid for the stamp duty and everything. So it is the tenant to pay for the stamp duty, as in the law it is the lessee, the person who lease from the lessor, the person who lease out. So the owner is actually the person who lease out, and the lessee is the person who receives the lease. So in the law, the lessee is to pay for the stamp duty right of the tenant when owner selling. So if you are in the aspect that you are in a commercial setting, you can use a certain way to caveat the transaction of the property, because you have caveatable right if you are long-term lease owner. Thank you very much. I am Thomasin, PA 2066. This is my mobile number. I have a few websites. Example, the findWHERE.info is a geo-linking platform for listing of property. Contract2you.com is a platform for ranking of property. Real Estate, you talk about how to choose between properties. So these are the way that I have designed to facilitate the selection of properties. Then my Real Property Online is a website that I have put up a lot of videos and write-ups. Because realestate.fund is a sample small agency website, directory-based agency website. Estateagentexam.com is a platform website for study of the diploma in estate agency examination, qualifying examination by the Board of Valuer, Appraisers, Estate Agent, and Property Managers for the e-license. Thank you very much, and hope you can continue following my channel for the next chapter, which is on portfolio. Thank you so much.